Every day, millions of text messages traverse cellular networks, carrying malicious links designed to silently harvest user data. Maya, a recent information technology graduate from Monash University, has developed an application to stop this. Her software identifies fraudulent text messages and detects malicious links before a user can open them. Maya possesses a functional technical solution. However, she lacks the legal and structural scaffolding required to protect her code from theft and shield herself from liability while attempting to profit from it. Transitioning a university project into a commercial asset requires precise legal structuring. Founders cannot rely on assumptions to protect their work. To evaluate Maya's position, we must apply a standard analytical engine used by professionals to solve complex legal and business problems, the IRAC framework. This diagram outlines the framework. The first stage is I for issue. This requires identifying the precise legal problem that needs to be solved. The second stage is R for rule. Here, we outline the specific statutory or common laws that apply to the issue we just identified. The third stage is A for application. In this chamber, the specific facts of the case, in this instance Maya's anti-fraud app, are directly mapped against the established rules. The final stage is C for conclusion. This provides the logical, actionable output of the entire analytical process. Forcing data through this strict IRAC pipeline generates a defensible legal strategy, replacing founder guesswork with systemic engineering. We begin with the primary issue for Maya. What types of intellectual property under Australian law actually apply to her anti-fraud application? Moving to the rule phase, software is protected by a multi-layered legal strategy: copyright, patents, and confidentiality. The first pillar, the Copyright Act 1968, dictates that copyright automatically protects original literary works the moment they are recorded. Under Australian law, software source code is explicitly classified as a literary work. The second rule pillar is the Patents Act 1990. Patents are designed to protect novel, inventive methods or processes. Australia maintains a strict legal threshold for software patents. An algorithm must constitute a manner of manufacture to be patentable. A manner of manufacture is a legally recognized category of invention that produces a tangible, physical result. The third rule pillar is common law confidentiality. This protects valuable trade secrets, provided the owner takes reasonable, proactive steps to hide them from the public. A comprehensive legal defense requires a precise understanding of how these three separate pillars interact simultaneously. We now shift the engine to the application phase, analyzing how Maya's specific anti-fraud app interacts with these three legal pillars. Applying the copyright rule, Maya's literal lines of code receive automatic protection the exact moment she types them into her code editor. However, copyright only protects her specific written code. It doesn't stop competitors from building a completely different application using the same underlying anti-fraud idea. Applying the patent rule requires assessing whether Maya's fraud detection algorithm passes the strict manner of manufacture test. To pass, her algorithm cannot simply be an abstract calculation or a mathematical formula. It must create a material technical effect on the hardware itself. Proving this technical effect involves a highly complex and expensive legal process, making it a difficult immediate path for a solo graduate. Applying the confidentiality rule exposes Maya's immediate vulnerability. If she discusses the underlying logic of her app with potential business partners before launch, she risks forfeiting her intellectual property. She must actively utilize non-disclosure agreements, or NDAs, to convert her secret business logic into legally protected confidential information. An NDA is a binding contract that establishes a confidential relationship and penalizes the unauthorized sharing of information. Moving to the conclusion phase of the engine, we formalize Maya's final IP strategy, rely on automatic copyright for the code, enforce mandatory NDAs to protect the logic, and delay patent assessment until sufficient capital is raised. Applying IRAC identifies that while some protections are automatic, others are resource-intensive. This process replaces the impulse to chase every available right with a prioritized, pragmatic sequence of protections. We reset the IRAC framework to introduce the second issue. What are the main legal and structural considerations Maya must account for when establishing her business? In the rule phase, we evaluate corporate structures across a horizontal spectrum. Founders weigh liability, setup cost, tax obligations, and capital raising potential. The sole trader rule offers the lowest setup costs and simple tax requirements. The trade-off is unlimited personal liability for the founder. The proprietary limited company, or PTY Ltd, exists as a completely separate legal entity from the founder. A PTY Ltd is a private corporate structure in Australia that restricts share transfers and limits shareholder liability. This corporate shield requires higher initial setup costs and mandates stricter ongoing regulatory compliance. A partnership structure serves as a middle ground rule, though its requirement for multiple co-owners makes it less applicable to a solo developer like Maya. Selecting the correct business rule is a calculation of how much personal risk a founder is willing to tolerate in exchange for lower administrative costs. We enter the application phase to assess the specific risk profile of Maya's application. The inherent operational danger is severe. If Maya's app fails to detect a malicious link, the resulting financial damage creates a massive liability shockwave. Applying the sole trader rule to this scenario shows a vulnerability. Lawsuits from hacked users could allow creditors to seize Maya's personal bank accounts and future assets. Applying the PTY Ltd rule demonstrates that the corporate entity absorbs the liability. Maya's personal assets remain untouched. We must also apply the capital raising rule. Cybersecurity startups frequently require external funding from investors in order to scale their infrastructure. Sophisticated investors mandate a PTY Ltd structure. They buy shares in a protected corporate entity, never in a sole trader business. In the conclusion phase, the output is clear. Maya must incorporate a proprietary limited company before releasing her application or seeking investment. For a high-risk technology venture, the business structure operates directly as a defensive weapon against catastrophic liability. Zooming out to Maya's fully constructed architecture, we see the final configuration. The intellectual property outcome ensures her code is secured by copyright, and business logic is locked down by confidentiality agreements. The business foundation's outcome ensures her personal financial future is secured by the PTY Ltd corporate shield. Contrast this secure architecture with Maya's starting position, a vulnerable graduate holding raw, unprotected code. Transforming that vulnerability into a defensible, commercializable asset is the goal of tech entrepreneurship. This transformation requires eliminating guesswork from the strategic planning process. Success is achieved through the rigorous, systematic application of the legal IRAC framework. Technical innovation provides the value, but the legal framework provides the container for that value. For Maya, this systematic approach transformed a vulnerable codebase into a structured business foundation.